Good afternoon, everyone. We'd like to welcome you and thank you for joining our webinar, 10 Common Posting Compliance Mistakes. A quick note before we get started. Please feel free to submit questions at any time during the presentation using the chat feature on your screen. We will respond immediately to any technical concerns, and we will try to answer as many questions as we can about the material presented via follow-up emails after the presentation. Without further ado, here is Ashley Kaplan, our in-house senior employment law attorney. Ashley has been practicing labor and employment law for more than 20 years, representing employers in a variety of matters, from discrimination and harassment litigation to defending FLSA class action lawsuits. Here at Poster Guardi, Ashley handles our legal compliance and also oversees the teams responsible for researching all the posting laws and developing compliance solutions to meet our customers' diverse needs. As a special offer to our attendees today, Ashley will be available to set up a complimentary personal consultation about your specific posting compliance needs. If you are interested, please indicate that in the question box, and we will contact you to set it up. And now, here's our presenter, Ashley Kaplan.
Thank you, and welcome, everyone. Today, I'm going to go over the most common posting mistakes that businesses make. And by going over what not to do, I hope to give you a better picture of what complete posting compliance really means. And it's not just a matter of having the most recent posters up on the wall. That's what a lot of people think of when they think of complete posting compliance. Just get the most recent posters. But in fact, there may be some new posting requirements that apply to you that you're not even aware of. I do find that most employers aren't aware that they're missing a lot of mandatory labor law posters. For example, this could include mandatory posters that have to be posted in Spanish. There are a lot of requirements even if you have no Spanish-speaking employees, and that goes for other foreign language requirements as well. It could include some other examples. It could include city or county posters, posters for job applicants, posters that are required for, or posting solutions required for your off-site or your remote workers. Could also include additional labor law posters required if you have any government contracts or even if you operate in certain industries. There are also mistakes that we're going to talk about around where to post or how to post. Mistakes that have to do with, not posting in enough locations depending on the size or the layout of your facility. So there's really a lot more to posting compliance than most employers realize. And I know it's not great dinner party conversation, but I can tell you from speaking with colleagues and clients that most business owners and even managers or people who work directly in compliance just aren't aware of all these nuances. It's just not top of mind for most people running a business or managing other areas of compliance. But it certainly is important and can cause a lot of headaches. It can even affect your company's bottom line if it's not done right. Labor law compliance is also an area of employment law that is constantly changing. So it's a good idea to take a step back sometimes and just do a quick checkup to make sure you have everything you need for complete compliance. And that's the goal for today. So first, let's start with a basic understanding of labor law posting compliance. And then we're going to go into the details about what it takes to be in full compliance with today's requirements and why it matters. As most of you probably know, all businesses in the U.S. have to post both federal and state employee notices. And if you're in a city or county with mandatory posting requirements, you have to post those too. So on a federal level, there are currently 6 mandatory postings, and they're listed here on this slide. And this is sort of a framework. I'm going to be referring back to this throughout the presentation, so I just wanted to start with the basics. First, there's the posting issued by the EEOC, the Equal Employment Opportunity Commission, and this one covers anti-discrimination provisions and the protected characteristics under federal law. Next is the OSHA posting, and this one highlights important provisions of the Occupational Safety and Health Act. Next on this list is the FMLA posting, the Family and Medical Leave Act posting, and it gives employees basic information about their rights under the FMLA, their eligibility for leave, what benefits they can expect, And it also covers your responsibilities as the employer regarding FMLA leave and procedures. Then we have USERRA, which stands for the Uniform Services Employment and Reemployment Rights Act. And this one covers reemployment after military leave, anti-discrimination provisions, and other issues around health insurance and veteran protections. Next, there is the FLSA, which stands for the Fair Labor Standards Act, the FLSA posting. And this one notifies employees about the federal minimum wage rate, overtime rules, and child labor laws. This one is probably the one most people are familiar with. And then finally, there's the EPPA posting, and EPPA is the Employee Polygraph Protection Act, and this one lets employees know the rules around lie detector tests in employment. I just want to add, because I always get this question, this posting is mandatory for all employers, even if you don't use lie detector tests. It has nothing to do with that. It's still mandatory. So those are the federal posting requirements, and then on a state level, there are additional mandatory postings that are required for every business. And depending on what state you're operating in, this can add up to 15 additional posters. So that's a total of up to 21 federal and state postings per location combined. So you got your 6 federal and up to 15 state posters. And this, when we talk about state law compliance and state mandatory postings on a state level, this area of compliance is becoming more complex and difficult to manage over the years because more and more laws are being passed on a state level giving employees protection in the workplace. And with each new law that is passed, there's a potential poster update, or in some cases a brand new poster being issued. The state posters cover topics. A lot of times the state laws mirror the federal laws. They just maybe, go a little further or they're a little different. But the state posters cover topics such as a state minimum wage rate, fair employment, unemployment insurance, workers' comp, rules around smoking in the workplace, paid sick leave, or any kind of time off or sick leave or family leave, child labor, and then some newer areas that we're seeing like human trafficking, expanded parental care rights, and electronic cigarettes in the workplace. On top of this, we've gone over federal and state. On top of this, you may have additional posting obligations if you're in certain cities or counties that have their own posting requirements. And this is an area where we've really seen a lot of growth over the past couple of years. I'm going to show a list of the major cities and counties with their own posting requirements later in the presentation. But just as a highlight, at this point, I've seen up to 9 additional postings for a single city. That happens to be San Francisco. So these really add up. So as you can see, there's a lot to keep up with to stay in compliance. And on top of all this, if you're in certain industries or if you have any government contracts, there are even more mandatory posting requirements that apply to you. But all of this is going to be covered when we get into the mistakes. I'm going to spend a lot more time on these because some of the most common mistakes have to do with overlooking all of these additional posting requirements. So like I said, I'll be sure to go into more detail on that as we move forward into the presentation. Okay, so let's start with the first mistake, and that is underestimating the importance of posting compliance, or basically thinking that the risks are so minimal that it doesn't really matter. I hear 2 things a lot. The first thing I hear a lot is that government posting fines are so small that it doesn't really matter if we get caught. And the second thing that I hear all the time is, well, there are no poster police out there, so how could I ever get caught anyway? How would I ever get caught? So I'm going to address both of these misconceptions. So first, when it comes to the amount of the fines, I want to lay out the facts, and there have been some changes around this recently. The amounts are actually pretty significant when we're talking about federal government posting fines, and they can certainly add up if you have more than one location and you have the same types of violations. So all the fines are assessed per location. In the statutes for the federal postings, the government is now authorized to fine up to $33,000 per location for posting violations. It's actually, the exact number is $33,486. And that is based on the most recent increases that went into effect in January 2017. And again, that is per location. And government fines, when we're talking about government posting fines, they can be imposed for missing posters or having outdated posters, having old posters up. And something a lot of people aren't aware of is that this penalty amount just increased as part of a law called the Civil Penalties Inflation Adjustment Act. And that law just took effect for the first time in 2016. There was an increase in, I think, August 2016, and then another one in January 2017. But before that, before the Civil Penalties Inflation Adjustment Act went into effect, the fines were only up to about $17,000 in total. So that's a pretty significant jump. That's a pretty big increase. It basically almost doubled. Also, the Act calls for increases going forward each year on an annual basis to keep in line with the inflation rate. So these fines are expected to gradually creep up and increase going forward year after year. So that's just for the federal postings. On a state and local level, the government posting fines are typically between $100 to $1,000 per violation. Each posting, which we're going to get into, each separate posting has its own fines and laws attached to it, so they're really all over the place, but this is a range. Every agency and every posting law is a little different, but in my experience, I typically see state and local fines somewhere in this range, and typically around $500 to $750 per violation. Okay, so the second misconception that I mentioned is, well, there are no poster police out there, so there's really no need to worry about government posting fines in the first place. So the reality is the government rarely sends out representatives on a federal level just to enforce posting laws. That's true. Now, we actually have seen this on a state and city level where they're not called poster police, but there have been poster sweeps on a state and city level by the enforcing agencies or in some cases the state attorney general. But on a federal level, it's not that they're sending out government agents to go find poster violations, but government posting fines typically are assessed because the agency is on your premises for another reason. It could be an immigration-related issue, could be an OSHA inspection, an EEOC on-site, some kind of EEOC on-site investigation, or even just a Department of Labor audit. And, those can be triggered by any employee complaint, just one simple employee complaint. And, of course, the complaint or the investigation is usually unrelated to the poster. It has to do with the substance of the law. But the agencies and the agents that go out to employers' facilities always check posting compliance as part of any on-site visit. So while they're not poster police being sent out for that purpose, that's where you see the government posting fines in most cases. But the real danger with posting violations is actually related to employee lawsuits and employee disputes. It's not just about the government posting fines. And there are a few different ways that posting compliance comes into play with employee lawsuits. The first, and probably the biggest, is when it comes to the statute of limitations. In my experience defending businesses in employment litigation, I like to refer to the statute of limitations as the employer's best friend because it's the defense that allows you to have a claim stricken or dismissed just because it was filed too late. And that can really come in handy when you're defending against employment law claims. The statute of limitations, for example, for a federal discrimination claim is 300 days. It's different in each state based on state discrimination laws. But on a federal level, 300 days. That's not a big window for suing someone. For a Fair Labor Standards Act overtime case, or misclassification case, it's 2 years. So typically, if you get a claim from a former employee or an existing employee for a violation and the violation occurred outside of that time period, you can move to have that claim dismissed and avoid all the legal fees and also the potential liability. Even if there was a violation, you can move to have all of that dismissed just because it was filed too late. You can also use this defense to cut off damages for violations that occurred before that statutory time period. So it's really an important defense in almost every case, especially in cases where you have multiple plaintiffs or there's an allegation of a repeated violation which is really common, like in a Fair Labor Standards Act case. So, for example, if you have a misclassification, exempt, non-exempt of a job position, it affects a large class of people, and it could go back in time. Or if you have like a faulty overtime policy or a meal break policy, that can really mushroom out and affect a large group of workers over a long time period. So the problem is, if you have a posting violation, meaning either you didn't display the current poster or you're missing a poster, courts have begun to publish more and more decisions saying that if an employee didn't have notice of their rights, the statute of limitation is extended or told, and basically you cannot use it as a defense. So that's can have a really serious impact in any kind of employment litigation. So we've seen cases where normally an old claim could have been dismissed, but the court allowed the plaintiff to pursue the claim, and it ended up in a six-figure judgment or worse just because the posters were not up on the wall. So that's pretty significant. Another way that posting compliance comes into play in lawsuits or employment law claims is as evidence of bad faith, and that can be in any kind of related employment lawsuit, whether any of the laws reflected in the posters, whether it's the Fair Labor Standards Act or if it's a discrimination case or an ADA case. Each law is a little different, but under the various legal standards, a finding of bad faith, or on some cases it's considered a lack of good faith, same concept, a finding of bad faith can directly affect your damages. It can either mean your damages get inflated, the damage award against you gets inflated, or it can stand in the way of a good faith defense that would have otherwise reduced or eliminated your damages. So on this point, too, we're seeing more and more cases where posting compliance is one of the factors that courts are looking at when they're assessing these kinds of damages relating to good faith or bad faith. By the way, I know this whole slide gets pretty legal, and it's pretty complicated, these concepts. So I want to offer up, we do have a white paper that goes into all the case law and all the examples and all the different theories. I've only touched on a few here. So if you're interested in that, just indicate that in the chat box, and we'll be happy to email that to you after the presentation. And then just finally, to wrap it up on this slide, under the Family and Medical Leave Act, you can actually be faced with a civil lawsuit if the failure to post ends up interfering with someone's FMLA rights. So again, these are pretty severe consequences that you need to be aware of, and very good reasons not to take posting compliance lightly. Okay, the second mistake, which I still see a lot, is when businesses try to get all their posters from a single agency. So, for example, I'm talking about if you were to try to get all your federal posters by just going to the U.S. Department of Labor website. Or, more commonly, I see businesses going to their state's Department of Labor website expecting to get all the different state posters they need. One that's really common, I hear a lot, is when you rely on your workers' compensation carrier for your posters. And, they will provide the workers' comp poster and maybe some of the other posters required by your state, but a lot of employers think this means they have everything they need, when really you just have a fraction of what's required if you're relying on any of these single sources. So one thing that a lot of people aren't familiar with, and that's why I continue to see this, and it seems logical that you could go to your State Department of Labor and get what you need, but the simple fact is there is not a one-stop shop for free government posters. There's not a central place or a website where you can get all the posters you need. I'm talking federal, state, local, even all your state don't come from the same agency. All your state posters do not come from one agency. There's actually, across the nation, there are about 175 different agencies that are responsible for issuing these posters. And I'm just talking on a federal and state level right now. So just for basic general industry compliance, federal and state, there are about 175 agencies and about 370 different mandatory posters for federal and state law compliance. So in any given state, just managing posting compliance in one state alone, an employer would have to go to up to 9 different agencies to get the right posters, to get all that they need for federal and state law compliance. And then on top of that, there are also about 22,000 cities and counties, each with their own governing agencies and ordinances to monitor. Luckily, not all of the cities and counties have posting requirements, but a lot of them do. And like I said, we're seeing this number grow every day. I'm going to get into that in a moment. But none of these agencies, whether it's federal, state, or local, these agencies do not have work-share agreements where they provide, where you're not going to find one agency that provides all the posters that the sister agencies require. I have seen in a couple of states some of the agencies do a pretty good job and they try to help out, and you can see some crossover where one agency will have posters that are issued or governed by another agency within that state. But it's rare and it's not a complete list. And there's not a one-stop shop where you can get all the federal and all the state posters you need for full compliance. They operate separately. And certainly not on the city-county level. The local agencies really operate on their own apart from state or federal agencies. So if you're handling posting compliance on your own, it's important for you to be aware of this and make sure you're doing all the research and going to all of the agencies that enforce employment laws in your jurisdiction, not just your Department of Labor site. You need to cover all the federal agencies, all the state agencies, and all the local agencies. So this is just a quick visual of how many different posters there are for each state and how many different agencies you would have to go to in each state to make sure you're getting all the required posters. So in the first column on the left, it shows how many posters, actually how many individual postings are required. And this is just your federal and state postings for now. And it goes state by state. So this is just a good, quick, self-audit tool. So at a glance, you can see how many posters at a minimum should be up on the wall. And you can see in the left column that the number of posters required range from 9 to 21, and that's per state. And then the column to the right shows how many different agencies are responsible for issuing these posters in each state. So, you can see that in a lot of cases there are 7, 8, or 9 different agencies you would need to contact in each state to get the right posters. And again, just as a reminder, because we're going to get into a lot of additional posting requirements today, this is just your basic federal and state compliance. It doesn't account for city, county posters, industry-specific posters, or federal contractor postings. Okay, posting compliance mistake number 3, updating your posters only once a year. This is a big no-no, but a lot of companies still operate this way, surprisingly. Labor law posting requirements change all the time, not just once a year. Yes, it's true there are a lot of states where the state minimum wage rates increase once a year, and in some states it's always in January. So you would need to update your posters in January because of this. But if you only update your posters for the minimum wage change, you're likely to be out of compliance throughout the year when other posters change. Also, a lot of minimum wage increases go into effect at different times of the year. It's not always in January. So you need to be careful with that too. And when it comes to all the other laws reflected in these posters other than minimum wage, these laws are changing all the time, whether it's new laws being passed, amendments that change existing laws, or laws getting repealed. All of these affect what posters you need and when you need to display them. And the effective dates for displaying mandatory updates can be any time of the year, regardless of when the law is passed. So one of my responsibilities here at Poster Guard is overseeing the team of lawyers and researchers who monitor all of these posting laws on a daily basis. And I can tell you with certainty these posting laws change constantly, and that's on a year-round basis. On average, our team sees about 150 state law posting changes a year. And every time there's a posting change, we review the underlying laws to determine if it's mandatory or non-mandatory in terms of whether you have to replace the poster or sometimes it's just a cosmetic change and the old poster is still compliant. And out of the 150 on average changes we see, at least half of those do require a mandatory update or immediate replacement of the posters. That's on a state level. And on a local level, when we talk about city and county, sometimes we get 2 or 3 mandatory changes a week. It just depends. And the rate of change continues to grow as well year over year. So this is also a trend expected to gain even more momentum in the coming years as states and cities are continuing to pass more and more laws expanding employee rights or in some cases updating existing employment laws. And this is actually a trend we're expecting to see accelerate given the movement toward deregulation on a federal level. So the bottom line is if you're only updating your posters once a year, you may be okay with your state minimum wage, but you're at risk of being out of compliance when it comes to all your other postings. And remember, the state minimum wage is only one of many that you need to stay on top of when it comes to these posters. And by the way, just a side note, the federal poster changes rarely happen in January or really on any other kind of predictable cycle. They're really all over the place. We've seen changes come out in February, sometimes in June, could be in August, like the mandatory changes from 2016, they hit in August. And like in that case, the effective dates for posting compliance can be immediate with very little notice. So if you're waiting until January or some other point in time each year, or you're only updating your posters on an annual basis, you would likely be out of compliance for the balance of the year. Okay, the next mistake we're going to cover is overlooking mandatory foreign language posting requirements. And this applies to everyone, even if all of your employees are proficient in English. There are actually 22 states right now, plus Washington, D.C., where you're required to post certain postings in Spanish. So you're required to post them in English and Spanish regardless of your workforce demographics. Even if you don't have any Spanish-speaking employees on your staff, these laws apply. In these 22 states and Washington, D.C., there are actually 47 individual postings that have to be posted in English and Spanish. And a few states go even further, and we've seen requirements for a lot of other languages. We also see this a lot on a local level. A lot of the cities in California have requirements that you post in multiple languages. We've seen up to 11 different languages required. Russian, Japanese, Arabic, Mandarin, Creole. It just depends on the poster and the agency's guidelines. So that's a little bit all over the place as well. And just before we move on, just as a side note, in Puerto Rico, all of your postings have to be displayed in Spanish, and English is just considered a best practice. So this is the list of states that currently require certain postings to be displayed in Spanish, like I said, even if you don't have any Spanish-speaking employees. So for those of you attending the webinar today who are already Poster Guard customers, I just wanted to point out there's nothing that you need to worry about when it comes to these foreign language mandatory postings. Poster Guard automatically includes foreign language posters in the regular English service if they are posters required for every employer. So if the law says you have to post a particular poster in English and Spanish, even if you don't have any Spanish-speaking employees, the Spanish version would already be included with your English posters at no charge, and you don't have to request it. That's true for every foreign language, and that's true on a federal, state, local level. So that's just a given. If it's something that's mandatory for everyone, it's covered. And I know this can be confusing because it's called the English service, and we do have options for fully translated services in other languages. But under the English service, we think that in order to make sure you're entirely in compliance, if it's something required for all employers, it should be included, and you shouldn't be required to take any action or do any research or let us know or make any kind of decisions around it. It's mandatory. So if you're in any of the states listed here, there's really nothing to worry about when it comes to these mandatory foreign language postings if you have Poster Guard regular English service. For anyone attending today who's not a Poster Guard member, we will have some information at the end so you can find out more about the Poster Guard service and what it is. But basically, Poster Guard provides 365 days of complete and worry-free posting compliance. We start with providing you with all the mandatory posters you need, and then our legal team monitors all the laws, and we automatically send updated posters throughout the year whenever there's a mandatory change to any of the postings. So it's compliance throughout the year and keeping up with all the changes. So back to the foreign language requirements, if you do have Spanish-speaking employees or a large number of employees who are not proficient in English, there are some additional legal requirements that you need to know about. So, things change a little bit when it comes to your specific locations if you have a significant number of Spanish-speaking employees. So I'm going to cover that on this slide, all the different legal standards. First of all, when it comes to the federal poster, the federal combination poster has 6 postings on it. Those are the ones that we went over on the first slide in the presentation. If you have a significant number of Spanish-speaking employees who are not proficient in English, you need to post the federal combination poster in both English and Spanish. On a state level, there isn't a requirement that's written into the law that says you have to post every poster in both English and Spanish, even if you do employ a lot of Spanish-speaking employees who aren't proficient in English. It's not like the federal standard. However, most employers who have to post the bilingual federal poster because they do have Spanish-speaking employees, in most cases, these businesses choose to go ahead and post all of the state postings in both languages as well, just because it's a best practice. It would be, it might be difficult to explain in any kind of dispute or investigation why a choice was made that certain posters were posted in Spanish because, we knew that our employees needed to the information in Spanish, but we didn't take the extra step to post all of the mandatory notices in the language that our employees speak. So it's just a recommended best practice. It's not mandatory to post the state posters as well in Spanish if you know your employees don't read or understand English. There is one exception on a state level where it actually is mandatory if you have Spanish-speaking employees. In Pennsylvania, employers who employ Spanish-speaking employees do have to post all of the state posters in Spanish. Unfortunately, the agency that has issued this guideline doesn't provide a really clear definition of who this applies to. It simply says it applies to all employers with Spanish-speaking employees in Pennsylvania. So to be safe, if you have Spanish-speaking employees in Pennsylvania, you should be posting both the federal and the state, all of the state posters in both English and Spanish. So I just want to be clear because I know this can be confusing. When I talked about all the posters that are automatically included, I'm talking about posters that are mandatory for everyone, regardless of whether you have Spanish-speaking employees. Those are already in the service. They're already included. Now I'm talking about, and those are specific posters. It's not all of the posters required in a certain state. What I'm talking about now is going the extra mile and providing all of the state posters translated in Spanish. And that's where it's just a best practice, except for in Pennsylvania where it may be mandatory for you if you have Spanish-speaking employees. So one of the things about Poster Guard is that it allows you the flexibility to decide what you need for each of your locations. As you can see, based on these standards, it's probably going to vary from location to location. So if you do have locations where you want fully translated federal and state posters in Spanish, or if maybe you just want the federal, you would let us know that, and you can make that determination on a location-by-location basis. So you would just need to let us know that you want additional fully translated Spanish posters so we can add that to your service. Okay, another very common mistake is overlooking the local posting requirements that might apply to your business locations. So I've already mentioned this a couple of times, but it definitely warrants a separate discussion because so many businesses are simply unaware that these local laws exist. It is a fairly new trend that we've been watching, and most businesses just haven't caught up with the laws around city and county posting compliance. There are a lot of cities that now require businesses to post these additional employee notices. I've gone ahead and listed on this slide most of the major ones, and of course, some of the ones that are more recent that have popped up over the last couple of years. It's not a complete list, but I did want to highlight some of the major areas and some of the newer ones. I also wanted to highlight that a few of these actually require multiple postings. Philadelphia has, I believe it's now up to 7 additional city posters, and like I said before, San Francisco has 9 additional postings required just for city compliance. Now, again, not every city or county has posting requirements, but the number of cities and counties requiring these posters is really quickly growing. And it's really because, like we've talked about on the state level, with state and local government jurisdictions are passing more and more ordinances giving employees rights, giving them rights and protections that go beyond what's already provided under federal and state law. So this local piece, when we talk about city-county posting compliance, has actually become so important that Poster Guard has recently added resources to cover this. So now our basic service, the regular basic Poster Guard service, now automatically includes city and county postings for every location in the United States. So we've expanded. Our legal team is now continually monitoring all local ordinances and agency activity, and that's for all jurisdictions. So it's more than 20,000 cities and counties. And like I said, this is automatically included in with Poster Guard. So if you're a Poster Guard customer, a Poster Guard member, you're already getting these posters if your jurisdiction requires them. There's nothing you need to do in terms of requesting them. They're sent automatically, and as there are updates, and new posters are being sent whenever a new law comes out, which we're seeing a lot of. A lot of these requirements just came out, in the past 6 months or so, where the city never required posters, and now they do. So you're automatically getting updates, and you're automatically getting new posters as cities create new laws that require them. And by the way, I wanted to just address something. This is something I get questions on a lot. The city and county postings have to be displayed in addition to the federal and state posters, even if the information on the posters seem to be contradicting each other. I mean, even if the information conflicts. And this is really just because of the framework of how legislation works. States have authority to pass laws that are more generous to employees than under federal law, and city-county governments have the authority to pass laws or ordinances that are even more generous than under state law. So typically, you'll see that states have a higher minimum wage than under federal law, and then cities will have an even higher minimum wage rate than the state. So these posters cover much more than minimum wage. That's just the easiest way to illustrate. So as an employer, you have to follow the law that is the most generous to your employees. So in the case of minimum wage, it would be the highest minimum wage rate out of state, out of federal, state, and local. Or it could be the longest period of time if there's a paid leave. But so you have to follow the law that's the most generous to employees. But when it comes to the posters, you're still required to post all of the different versions of the posters. Okay, moving on to the next mistake, and that is overlooking federal contractor posting requirements. This is another area that's changed a lot in recent years, and there are so many different types of businesses now that are covered by federal contractor posting requirements. Everything from financial institutions to technology corporations. We see a lot of nonprofit organizations, auto dealers, and so many other types of retailers and service establishments. It's really grown. So the bottom line is, if you have any government contracts, so if you receive federal funding or you have contracts with the government for goods or services, there are additional employment posting requirements that apply to you. The specific posting obligations that you have as a federal contractor really depend on the type of contracts you have and with what government agencies. And then in some cases, it may also depend on the amount of the contract. The criteria is really all over the place. Each posting has a different criteria behind it as to who it applies to. And we've really found that a lot of businesses with government contracts didn't even know about this. They didn't know they were required to post these additional notices. So this is a really important takeaway, and definitely something you don't want to overlook. Also, the penalties for noncompliance can be even worse than what we discussed for the regular federal imposters. So when it comes to these federal contractor posters, if an employer doesn't comply with the posting requirements, there are not only steep fines, but you can also lose your government contract or funding. And that's typically written right into the contract. You probably are used to seeing that if you're a government contractor, where the contracts will say they can be suspended or canceled just because of noncompliance with posting requirements. So this is a list of the most common postings that are required for federal contractors. I'm not going to go into details on the specifics for each poster. I have and actually do create webinars just on this one topic alone that, we can go a full hour just on this slide. But I want to offer up, again, we have a great white paper on this as well. The white paper goes through each of the postings, and it helps you determine which ones apply to you. It goes through all the legal criteria. So if you'd like that information, just, again, use the chat feature, send the request to us, and mention specifically, if you want the federal contractor white paper, since I mentioned a different one earlier. The other one, you could just say general white paper or litigation white paper. This one is the federal contractor white paper. If you just request it, we'll be happy to email that to you after the presentation. So most federal contractors have to post multiple posters. It's rare that only one of these would apply to you. If one applies, usually 3 or 4 apply because the criteria overlaps. So we do offer, Poster Guard does have a full all-inclusive service that covers all of these. And that's just to make it easier and to make sure nothing falls through the cracks. It's just a personal preference, customer preference. We do offer them individually as well. So another point here, it's important to understand that these federal contractor requirements change frequently, and that includes new posters that are being created and issued, as well as posters that are updated with mandatory changes. You'll notice I've highlighted a few of the more recent changes here in red, but anyway, these federal contractor postings change a lot more frequently than the regular federal posters that all employers have to display. And that's really because a lot of these result from executive orders, and they don't have to go through the same legislative process. It's a lot faster. So I really think it makes sense to get an all-inclusive service that covers you for the existing ones. It covers you for posters as they change and also for new ones as they come out, just because of how much activity there is around this. Also, I think a lot of people would agree that we could see some changes to some of these underlying laws under the new administration. These are, for the most part, a lot of these newer ones are executive orders from the Obama administration, and they could possibly get rolled back or tweaked with the new administration. So that's another reason to consider a service with auto replacements. So even if a posting law gets repealed or rolled back, you would get a new all-inclusive panel with that poster removed. So it's just an easy way to stay on top of things and not worry about what to put up or take down as these laws are quickly evolving and as your government contracts are active or inactive. Okay, the next big mistake I still see a lot is overlooking your remote workers when it comes to posting compliance. And this is an area getting more and more attention, really just because of the trend that continues to grow toward employing telecommuters. So for years here at Poster Guard, going back to around the late 1990s, 2000, we've been getting questions. The legal team gets questions from customers saying they have employees who work at home and they want to know what are they supposed to do when it comes to these posters. Should they be sending these home-based employees full-size laminated posters? And we've all kind of laughed over the years trying to imagine someone working from home putting up full-size laminated posters in their kitchen or on their bathroom walls. And times have changed, so obviously that wouldn't work, and that is not required. It's still an option, but that is not required. But it is kind of confusing because by law, you are required to provide the mandatory notices to all of your employees, whether they work from home or out in the field or in an office. However, the posting regulations don't tell us exactly how that's supposed to be done when it comes to these off-site workers. They do tell you that you're required to communicate the information, but they don't tell you that you have to use a certain solution or do it a specific way, in terms of whether it needs to be paper or electronic. There are some more recent Department of Labor opinion letters and FAQs and court cases where employers have sent the notices electronically, and the courts have said, yes, that's a good alternative, as well as the DOL, that have said, yes, that's a good alternative, that makes sense, that's the intent of the law, you got the notices to them, and that's what counts. So that is compliant. So to help our customers comply when it comes to your off-site workers, we've developed Poster Guard e-service for remote workers. And I just want to stress, this is not a substitute for wall postings. if you have a facility where people report to work. But for your off-site employees who use computers or mobile devices for work and regularly communicate via email or use the internet for work, this is a fully compliant solution. And also, by the way, a lot of people ask me, at what point do you need to provide electronic postings to someone who works off-site? Like, what if they visit the office a few times a year and they see the posters up on the walls when they visit in person? Is that enough? And the Department of Labor has recently addressed this. The Department of Labor has provided some guidance, I think it was in an FAQ they published, where they said, if an employee visits your facility with the physical wall posters displayed less than 3 to 4 times a month, you do need another solution to provide the postings to them. And then they specifically mention electronic postings as one way to satisfy that requirement. So if you have workers who report into your physical facilities with the wall posters less frequently than 3 to 4 times a month, you should make sure you're getting the notices to them some other way. So this is just some additional information about how the Poster Guard e-service for remote workers works. So first you would just provide us with the email addresses and zip codes for your remote workers, and then we pretty much take it from there to communicate everything that you need to keep you in compliance. We send a welcome email. We start out with a welcome email to the off-site employee, and the email has simple instructions requiring the employee just to simply click and view the mandatory posters, and then this is automatically saved as an acknowledgement with the date and time when the poster is reviewed and the employee's name. These acknowledgments are all saved to our members-only web portal. It's a password-protected site. It's the same site where you can access and manage your account and where all your poster information is maintained for record keeping. So there's the initial email that goes out when the employee is first signed up, and then whenever there's a mandatory change, we automatically send another email with the same instructions. So we tell the employees, your posters have changed. You're required to click here, and you have to view the updated posters. And, of course, that is saved as well. And then the employee has access 24/7. They can always go back on their own and view the current posters just by signing in with their email once we get started. And the legal team, the Poster Guard legal team, manages all of the images. We host them in a secured environment, and we manage all the images. So they're always up to date and complete. So anytime your employees want to link and look at the posters, they're getting current and accurate posters. Okay, the next mistake has to do with industry-specific labor law posters. And these are additional employee notices that businesses have to post based on your industry. So there are actually a lot of industries nowadays that have these additional posting requirements that go beyond the regular federal and state postings that we've all been talking about that all employers have to worry about. The ones that have the most, and we're just talking about employee-facing notices here, not the kind of posters that you need for customers or patients or guests. Just for employee-facing posters, there are actually several additional posters required for public sector employers, employers that are in the healthcare industry, and employers in the restaurant industry. And because these three industries, public sector isn't technically an industry, but because these three areas have the most requirements, and because they do vary from state to state, we've actually developed a full-service 50-state solution for businesses that are affected by these additional requirements. So I'm not going to spend too much time on this because I know it doesn't apply to everyone, so just a couple of words. Poster Guard for the public sector, not to be confused with publicly traded companies. We're just talking about the public sector, which are government employers. They have a lot of additional requirements. Public sector employers even have a different federal poster, and then on a state level they may have posters ranging from E-Verify, Right to Know, whistleblower protections, notices about electronic monitoring and privacy. They also can have different smoking rules, so it's important to get a specialized solution if you are in the public sector. For healthcare, in addition to the regular posters, there could be up to 15 additional employee-facing postings that are required depending on your state. In some cases, it also depends on what type of facility that you operate, what type of equipment you have, if it's radiation, that kind of thing. There are also notices that could be having to do with patient rights in terms of telling employees about patient rights. Special overtime rules for employees. There's some posters around that. Some special posters about ethics and complaint procedures. And again, it varies from state to state. Similarly, for restaurants, there are a number of additional posters that could be required based on state law. Just some quick examples: choking, notices for tipped employees, CPR procedures, information telling employees about the laws around serving alcohol to minors. And believe it or not, the posters from state to state on how to wash your hands are actually different, and they are mandated by state law. In some states, you have to have a certain image and certain language and colors and fonts and everything on employee hand washing. I did want to mention there are also additional posting requirements for other industries, just not enough posters where they warrant a full service 50-state solution, but just some examples. If you're in agriculture, transportation, adult entertainment, there are a few others, but you do have additional obligations as well. They're not as many. They're just a few posters depending on the state, and we do have specialty posters that can help you comply. If you want more information on that, let us know. Okay, another very common mistake is failing to post in proper locations or failing to post adequately throughout your facility. And this is probably the area where I get the most questions on a day-to-day basis from customers. Where should we post? Do we need multiple poster sets displayed per location, or is one set enough? And the answer, of course, is it depends. I know lawyers always get made fun of for saying that, but I'm going to explain. So all of the posting statutes, remember they're all individual laws, all of the posting statutes have their own specific language about where and how to post. But the general rule, when you roll them all up together, is that the posters must be displayed in prominent and conspicuous locations throughout your business where they are accessible to all employees. Accessible to all employees means basically they need to be in areas that are frequented by employees and frequented by all of your employees. So in a small office, you may be able to you may be able to satisfy this requirement just by posting in one location, maybe your employee break room. If you know that all your employees have access to it and use it regularly, and that's the one place where employees gather away from customers or guests, that would probably be sufficient. Or another example, if you have a building where you only have one employee entrance and all the employees have to use the same entrance to come and go, that might be sufficient. I've also seen scenarios where there's just one area for employee restrooms and there's only one hallway leading to it. There's only one way to get there. That hallway might be enough if you just post your posters there. But for most companies that I work with, you're probably going to need more than one posting display site to make sure that all your employees have regular access to the posters. And the number of posting display sites that you're going to need in each facility really just depends on the logistics and how accessible the posters are to your employees. So, look for highly visible areas or high traffic areas. And that's, really the way to start, I think, when you're looking at your facility. In a big facility with a lot of square footage, this could mean, to cover all the different areas. Think about posting maybe near, each employee entrance. Think about, posting in the employee break room, or if you have an employee locker room. If you have a designated HR department or HR office, you might want to post, outside the HR offices. That's where employees expect to go for things like this. Another idea, if you have a large facility and you have a lot of non-exempt or hourly workers, if you have traditional time clock stations, if you use, time clock stations, hang them near your time clock stations. You know the employees are going there. Also, just a side note, you also need to be aware of applicant area posting requirements, which we're going to cover in just a moment, but I just wanted to throw that in here when you're considering your facility and where to post. So basically, it really just depends on the layout of your facility, and unfortunately, there's no magic number or formula provided by the regulations or the agencies. It's very specific to your company. I've had some clients in high-rise buildings who have needed to post on every single floor because there isn't a main entrance that all employees share. Other clients in facilities with multi-levels have gotten away with posting only on the ground floor because all employees use the same entrance to get to the stairs or the elevators. They have to pass by the same area. Another example, if you have two or more buildings, like on a campus, and not all employees frequent every building on a regular basis, you would need to post in each building. So it's really specific to your facility, but you need to think of all your affected employees and make sure you have the posters in areas where they will access them frequently in the regular course of business. Also, don't put them on the backs of doors that are closed or closet doors that are closed. And finally, we're just going to touch briefly on this last one, and that is applicant area postings. And this is an area of compliance that a lot of people aren't that familiar with, but it's really important because with an auditor or an inspection officer that comes in, they really don't have to go that far to see if you're in compliance. And a lot of employers don't realize this, but out of the 6 mandatory federal postings that we went over on the first slide, 4 of those have to be displayed in areas where applicants and employees can view them. So you have to make sure applicants can view them. The 4 postings are the EEOC, FMLA, USERRA, and the EPPA postings. So you can see on this slide we have a few different solutions to help you comply. If you have applicants coming into your facility for any reason, whether it's to fill out an application or to participate in an interview, you need to have the posters physically displayed on the wall, just like regular employee-facing posters. So we have a small version that's sort of a vinyl adhesive peel-off removable sticker. It's more compact, and it just has the 4 mandatory postings. And then we have another option. It's a little bigger, a little more comprehensive. It's just a laminated poster with the 4 mandatory postings, and then also by customer request, we've added 2 additional best practice notices to this larger version. So one just informs your applicants that you comply with immigration laws and I-9 requirements, and the other notifies applicants that you're a drug-free workplace. And this one is really more ideal for a larger company with like a dedicated applicant area or an interview room or a place where applicants can do pre-employment testing. And finally, don't forget that you need to make sure you're providing these postings for your online job applicants as well. So these are also available in an electronic format, so you can just add that link to your existing online application platform or whatever you're using for your online applicants. Keep in mind, though, electronic postings, as a general rule, are not a substitute for the wall postings. There are just a couple of little exceptions, but when we're talking about these applicant area postings, the electronic link is not a substitute for the wall postings if you have applicants coming into your facility for any reason, like for a pre-hire interview. But you would also need to post them online electronically if you're accepting applications online. Okay, well, that wraps it up. I hope you found this presentation to be helpful and informative. I know we went over a lot of information and legal requirements and details, but there's really a lot to share when it comes to these laws and what it takes to be in full compliance. And it's constantly changing. So if you have any questions or would like additional information about Poster Guard or any of the compliance issues that I've talked about today, please feel free to contact our compliance specialist, Peter Frey, at 954-970-5702, or you can reach Peter by email at pfray, P-F-R-A-Y, at hrdirect.com. Thanks again for attending today's presentation, and we hope you have a wonderful afternoon.